Welcome in, everyone. It is Thursday, December 16th, 2021. We got two more Thursdays after this one left in the year. I'm Mark Reel, and I'm coming to you live from Lake Placid, Florida today, a little pre-Christmas trip. And we have a guest joining us. He's going to be our first three-time guest. I think you were our first two-time guest. And he's got a lot of exciting things going on that I know a lot of people want updates for. So our guest today, we're a little bit early this afternoon, is Minnesota Attorney Ryan McLaughlin. Ryan, how are we doing today?
Mark, thanks for having me back. It's always a good conversation. I know you have your, every week you get to have these conversations, and it's always a pleasure to kind of pick your brain and put this information out there. So, the two prior times we focused a lot on the Constitution for folks in family court who want to see their kids more. And we focus on the Constitution, right? Because it's a weapon that's never used. And it's a weapon that it's the highest court in the land, right? The U.S. Supreme Court, the Constitution. And so from New Jersey to Washington State, Oregon, right? All this, every single state, if you make a U.S. Constitution argument, you win. And you don't see those, right? Local attorneys don't see those. You don't see people litigating. I have a federal constitutional right to see my kids. And so a lot of that's been what I've been working on and what we've talked about already and ground we've covered. Today, I kind of have a couple more angles on that same idea. Nothing new, but a couple more, a few updates that I wanted to talk to you about. And, I wanted to start with just sharing kind of boots on the ground update from life in Minnesota, life in COVID. So there's a case I'm aware of, a client I'm representing who's facing going to jail in early January for not paying enough support monies, right? So he pays support, he pays child support, and he pays spousal support. But the court has said, you're in contempt of court, and you either purge your arrears and pay up, or see ya, right? You're going to jail. And And I raised this for a couple of reasons. One, this is serious, right? This is you're going to jail, and they say that it's not a punishment that we're putting you in jail. It's to help you. It's to encourage you to pay, right? But like, how are you going to pay when you're in jail, right? I mean, under what logic, right?
Are they going to give you a job and you're going to pay using that $1.38 or whatever they pay you when you're in prison working a job? Like, what are we doing?
Yeah, right. So that's one, right? And we laugh, but it would be terrifying if this was me, if I was in this position.
Well, think about this. Let's think about this. And this is something I'm sure you see. COVID impacted so many people financially. And there are so many people that have arrears that are well-meaning, that made all of their payments and then lost their jobs. And maybe they didn't go out right away and get that modification. And I know out here in California, we're just starting back up enforcements. So what are those enforcements going to look like? Are we going to start taking people's licenses in bulk? Are we going to start locking people up in jail because a pandemic took their livelihood away from them? It's going to be an interesting question. And I mean, I think it ties into the constitutionality. I mean, these were government mandated shutdowns that cost people this money, that cost people these jobs. And now the government a different arm of the government wants to come around and punish them for that.
Yeah. And the thing I'll say is, I'm a lawyer, but a lot of my work is done by my clients, right? So if you're watching this, if you're a mom or dad, whatever, you have an incredible amount of power to pay attention to stuff, right? So for instance, if the court's saying that your arrears are $100,000, maybe they are, but in many of my clients' cases, they're not, right? The court is understaffed, overworked, and right, they're and this is true with a lot of government entities. So because it's your case, your life, your bank account, your payments, better than them. You just don't have the power. So
better than your attorney, and you need to realize that.
100%, 100%.
I tell all my clients, here's the deal. My job is strategy. My job is to put you in the best position possible. But there is no possible way, even if I spent 80 hours a week on your case, that I even have a fraction of the knowledge and understanding of what's going on in your day to day life. There's a lot of pattern stuff that, I mean, I know you see it too, Ryan, that's like this situation's occurred. So we know that this is the strategic move we need to make, but each situation's different. And I think that's the big thing I always tell dads is you got to take ownership in your situation, because I'm only as good as the information I'm given,
Yeah.
and you have to own the facts in your case.
Yeah. So the tool here would be right first, double, triple check whatever the court's saying or doing. Double, triple check the court order. And I mean
In
this in
most states, you can request an audit. You can go to child support and say I want my case audited, and they have most states have a time frame in which they must audit your specific case.
right. So that's number one, right? Make sure if you're the petitioner in a case and the respondent just won based on their version of the facts, make sure that whoever the opposing party is, make sure that their facts match up with the county audit, right? With what the county has on record. And then make sure that that's actually what you paid. Because sometimes you pay via check, or I don't know how you pay support, and it doesn't get counted, or it gets claimed as this when it's supposed to be that. Make sure the facts are right, because the court, I think, both doesn't care as much as you and isn't equipped to handle the kind of volume it's seeing, right? So they're just you know they're drowning, right? They're drowning.
Yeah.
And so you have to care. That's number one. Number two is for the attorneys out there. So that's for the litigants, for the clients. Number two for the attorneys is we're also inundated, right? We're also trying to help all these clients, this, that, and the other. But I think it's important too, and this is something that I have to do as well. Read the orders super, super carefully, right? Because if the court doesn't make findings of fact, if it gets the facts wrong, if it gets the law wrong, right? This is something to bring up, and it's something to hold like a torch to the court's feet and be like, your one job, judge, is to get the law right, and you get the law wrong. And it makes sense. These judges are shuffled around from family court to civil court to criminal court. They're not getting paid oftentimes as much as attorneys. So mistakes happen. They misstate the law, and when you catch it, it's a time to make a big to torch it, right? To say we got a huge problem here, judge.
And this is something I think the internet, I think you make a really good point. And I think the internet, I think Facebook as kind of a melting pot of dads and parents coming together, is we're seeing more and more often judges either going outside of the scope of their duties, or doing things kind of rogue on their own. I talked to a colleague of ours that a fellow attorney who is in Illinois, and there's people in hot water because they recorded court proceedings and then caught the transcripts being incorrect, and they were able to, with video, go in and say the transcript is incorrect, that's not what happened, and then they try to punish them. But it was a big deal with their child custody case.
Yeah. So the attorneys need to pay attention. The attorneys need to be proactive. The attorneys need to, and that's a general statement, right? What I'm specifically talking about is, right, every what did you say, Mark? Yeah, so the transcripts can be messed up versus what's actually being said. That's one example. But even case law, right? So in Minnesota, there's case law for everything, no matter what state you're in. There's the best interest standard has case law, case law for every situation. In the situation that I'm talking about, will throw you in jail. That situation will throw you in jail for not paying your child support. In Minnesota, there's a case that it's called the Mahadi case, right? This case says this is how we're going to throw you in jail. This is what your rights are. You get this hearing to determine how much you owe. You get this hearing to determine if you can pay it. Then you get this hearing to say at the very end, please don't throw me in jail because of X. And that's a right. Like a R, like capital R, that's a right. You get it no matter what. It's not you didn't show up. It's not, we didn't like you. You have to have that hearing. And the court messed that up, right? The court didn't read that that line of the case, which it's a real important line, right? It's just not super
Yeah.
important to the court, but it's real important if you're a dad who's or a mom who's potentially going to jail in January for not paying money. Like you have a right to this hearing. Um, and so the question is, if you're an attorney, what do you do about that? And the only thing that I found as you can't often correct the judge. That doesn't go super well, right? It doesn't go over real well to tell the judge, Your Honor, you made a mistake here. Because
Mhm.
probably, right, there's an adversary. So what I found is find colleagues, right? Find as many colleagues as you can. Find as many senior attorneys as you can. Find as many senior county attorneys as you can who are of that inside position, who have more seniority than the judge. And then just but just throwing mud back at the judge, I don't find to be super effective, right? I feel like
No.
so that's
Not in the micro, at least. Not
not
in
in
that
the
person who's in front of the judge's case right then and there.
right, exactly. So two things. One, people should pay attention to the facts to make sure the court gets the facts right. And this is specifically the clients, not the attorneys, because the attorneys don't know the facts. The attorneys should be looking at those cases and triple checking the judge's order. Oftentimes the attorneys just skim, right? We'll skim to the good stuff, the bottom of the order where it says granted, denied, granted, denied, granted. But we miss, the whole thing could be the whole order could be flawed if the judge doesn't have findings of fact and conclusions of law, or if they mess up either. Which is a long-winded way of saying attorneys need to also slow down, right? You could be lethal if you slow down. And so I'm as guilty of that as anybody, right? So it's a good lesson for me. It's something
Yeah.
I've been focusing on, and it's happened right now. And I think anybody in family court can help their attorney slow down. Just they could read the orders themselves, right? So that's one thing, right? Just right off the bat.
I want to stay on that too. And the one of the things, and you mentioned having colleagues and educating other people that are in front of the judge, so maybe these issues get brought up. I think one of the most tactful in the micro. When I talk about micro, I'm talking about that individual client. Like the macro, the system, there are all sorts of issues. But when we step in the courtroom, it's about the micro. It's about how can I get the best possible outcome for that client I'm representing right then and there. And I think whether you're pro se or whether you have an attorney, there are the resources out there now to be able to brief the judge on the issues, to educate the judge. Now, it may not be admissible in terms of evidence, but there's nothing that says you can't file a brief that has a section explaining technically what parental alienation is or explaining what the case law specifically is. And that can sometimes help you get out in front. I would say in the last 3 to 4 months, I've become big on before a hearing. If there's going to be an issue, I put the case law in front of the judge beforehand. So it makes it harder and I can reference it and I can kind of angle myself as like, hey, Your Honor, like on the law side, you see, I talked about this case law that would apply here rather than just trying to throw something at them after the fact.
Yeah, I think that's important. I think that's important. And it's nothing radical, exciting, sexy. It's just saying, you know, know the law, basically, right? Just like a plumber has to know
It's
the
boring.
pipes. It's boring, right? Exactly. But
Every
it's
single domestic violence hearing I go into, I have about a 5 page section of a brief that lays out specifically just to kind of put it in the judge's head. This is why you would, or this is the level they have to reach to get a restraining order granted. And this is the case law that puts that in a box. So you can kind of, in my mind, I've kind of seen where it maybe removes a little bit of the discretion they may have, and it kind of prevents that judge from being very fast and loose with the law because you've put it in front of them and said, "Here's the law. We know the law. This is the laws we all have to follow."
I like that. I like that. And I don't know why that gets overlooked. And maybe viewers or listeners are like, yeah, like that's the basics, right? That's what you should be doing. But that's precisely the point, right? It's what you should be doing, but too often it's hard. It's not sexy. It's you have to sit down and think, and it's grinding. And I think attorneys like myself, like you, Mark, we need to make that's the meat and potatoes, right? That's what our practice should be. And so I take that to heart. I take that to heart because it can save somebody. That it's the difference between someone going to jail and not, right?
Yeah. Yeah, and
Um,
I've talked to so many. I've had the opportunity. You said every single week I get to sit down and talk to people. I've talked to people that do actively practice criminal law, where they've represented people facing life in prison, and the next day they're representing somebody in family court, and they say that, hey, it's more stressful going in and fighting to ensure that someone has their constitutional right to parent than it is defending someone who may be facing serious time in prison. So, I mean, that's a perspective that I've only done family law. That's all I've ever done. But that's perspective from people who are, I know you kind of had a little bit broader practice, but that's the perspective and that I've gained, is that it is serious, and we need to take it to heart, and we need to take all of our clients. It needs to be a personal issue for us.
so yeah, agreed, agreed. So that's kind of like that's happening right now. That's in the micro for me. That's what's happening right now in Minnesota is, you know, going to jail, and that just shows how serious we're what we're dealing with, right? You can go to jail because you can't pay because you lost your job or lost income. You can't pay what you were expected to pay before COVID, right? And you've shown the court, you've done what you've done, but the court um, doesn't particularly like you because you've made constitutional claims in the past, this, that, or the other, you name it, the reasons why, right? Um, and that's the landscape we're in. And I think what we were just talking about is, well, if you're in this landscape, this hostile landscape where you're going to jail if you don't pay this amount of money, what do? You do all the things we've just described. So that's kind of first thing that was on my mind. And then, let's talk about some big moves that your attorneys can make. One thing that I've been thinking about is, why don't children have standing in family court, right? The family court, the whole thing about family court is it's about the best interest of the kids. That's the whole deal, right? It's all about what does the research say is best for the kids. The whole court system, that's the central banner, the paramount concern.
Mm-hmm.
So, and the parents are always fighting about it, right? Parents get divorced and then they hate each other, they quibble about money and then quibble about the kids. But why don't the kids get a chance to say, I love mom, I do, but I only see dad, for every other Friday and Saturday. Why don't I get to see dad every week? I love dad. I love hanging out with
Mm-hmm.
dad. I'm just using dad as an example. I'm 13 years old now. I have a higher SAT score than both mom and dad. I'm a smart kid. Uh, I want to tell a judge why I think I should be able to see my parents equally, right? And there's a huge concern about kids and kids being taken advantage of and the court being kind of an adult scenario and situation, but it's an interesting legal question. Why don't kids have the ability then to be represented by their own counsel? Well, never mind a guardian ad litem or whatever your state calls a protective counsel for a minor, but for a kid to say, I have a right, right? Because the same Supreme Court case law, Troxel v. Granville, stands for the same proposition. Kids have a right to their parents and vice versa. So if that's the case, let's enforce the kids' rights, right? Let's see mom and dad as petitioner respondent, and then as intervener, right? Little daughter or little son, and what would that look like, and why? Because that's the center focus, right? It's not actually mom versus
And that
dad.
would be
It's
interesting.
yeah,
And I do know this, and I don't know the specifics of it, and this is probably a conversation and something they'll have later. I do know of an attorney who has made it to there's an appellate court decision in the Seventh Circuit, so that's Illinois, Indiana, and Wisconsin. I went to law school in that circuit. I should know, but it gives kids rights, and it kind of opened the door for federal lawsuits. So I think for me, the amazing thing is I used to think, and I think a year ago, I thought that suing, like, why do we need federal court? Why do we need these lawsuits? And I think in the last year, we've made such progress. There have been probably about half a dozen cases at the federal level that have carved things out that are heading in that direction. because I think any attorney would say we don't really do it too much out here in California, but the guardian ad litem or child's attorney, whatever it's called in your state, there's just so many issues. I know one major U.S. city, there's a current FBI investigation that's not public yet into their head guardian ad litem in their program.
Yeah.
We've seen the news out of St. Louis where there's the videos of Cash for Kids, and I know Kenneth Rosa has done a lot of work on that, and he was personally affected by it. So it's one of those things we've made such strides, whether it just be making things public and making judges aware, because I'm kind of curious, and this is a question I've started asking to some of my peers who don't work in family law. People, I don't even think most attorneys who aren't family law attorneys or don't enter this sphere understand what goes on in these courtrooms.
What do you mean specifically?
Like,
Like
I don't think.
what?
I'll take my situation specifically. So I ended up in family court within 8 months of graduating law school. And when I was walking in for that first hearing, I had my attorney, and I had studied labor and employment law. I'd worked for management side firms. I'd seen how the court system works.
Mm-hmm.
And in my head, I'm like, I'm going into a court in the United States of America,
Mm-hmm.
and I am a willing, able, and fit parent. The courts will figure this out. This will be easy. And now you see it. I see it day in, day out, whether judges being lazy or just falling into the trap of, oh, this kind of follows this fact pattern, so I'm gonna start the dad out with supervised visits, or I'm gonna start the dad out with 3-4 hour visits during the week, and maybe 6 months from now I'll give him an overnight. You kind of don't expect that. And I think that for me, something that kind of shook me, I don't know if you're familiar with Mark Ludwig, who Americans for Equal and Shared Parenting.
No.
He posted on his Facebook page, and it kind of hit me. It made too much sense. And I don't want to tell his story, but in a sense, he was a father who the mother ran from him, withheld the child, went into hiding, and it was almost a year that he didn't see his essentially newborn son. And when he finally got into court to get custody and visitation orders, they gave him supervised visitation because he had never taken care of the child. Well, do we give parents who are taking their first child home, do we send someone home with them to take care of the child? And when he posted that, it hit me. I'm like, the supervised visitation scheme. I'm gonna call it a scheme because it just makes therapists and whoever in your state. In California, it's a joke what you can be to be a professional supervisor. It just makes them hundreds of thousands, if not millions of dollars a year.
Mm-hmm.
And it's just completely and totally unnecessary. So I think that's one of the things in terms of, I don't know if my peers outside of family law fully comprehend really the insanity of men and women having to prove they're a fit parent. But I mean, if there's no conflict, it doesn't matter if you have DUIs, drug arrests, felonies. If you have the kid and there's no concerns at the time, they go ahead and send you home. But one person, opposing party, says, oh, I might have a concern. They put all these restrictions on that person.
Yep. And people might think that you're blowing when you hear these rants. And I don't want to say that what you just did was a rant, but it kind of was a rant.
Oh, it was a rant. I was on my soapbox. It was a rant. I'll own it.
Yeah, it was a rant, and you often see and or hear these rants, right? So someone's pissed off about family court, and then they tell you why, and it comes off as a rant. But oftentimes, and I think too often, like what you're saying is factually true. You're not exaggerating or lying. What you're saying is factually true. There's these problems in the court, these holes, points of breakage, where, just like you said, it's not a rant. One accusation against somebody could cause in the court's mind the dad's visit to go from unsupervised to supervised, like that, right? One accusation of anything, you name it, it could cause a credibility shift that the dad can't overcome, and then it's just the slippery slope. It's like an avalanche from there. And that's right? That's a problem. And to your point about federal court, I think federal court can help solve that problem because the standards of the bench are a little higher. The rules of practice are more strenuous, right? There's more hoops you have to jump through as an attorney. Everything has to be a little bit more precise in terms of, even in
Hmm.
terms of just, your margins and the page numbers and the word count, and everything is just dialed in a little bit more. So the
All
fact,
11 copies of each filing you have
yeah,
to
yeah,
submit and
yeah,
everything. Yeah.
all this kind of like this kind of like a charade, right? That you have to do
Uh-huh.
this and write in cursive for this, but it makes a difference because you can't be sloppy. You can't be as sloppy. And I think one of the problems is it's kind of the wild wild west in family court. It's kind of like you just walk into someone's living room and they get to decide. And I think so. The reason you go to federal court is it's a little bit more expensive. It's a little bit more difficult on the attorney side, but you're now playing in the professional league where these are, so, and what I mean by that is you have a chance of fairness, a higher chance of fairness. So when we talk about, when someone says I'm getting, when someone goes on their rant and they say, what can I do? What's your game plan as an attorney? What's your genius game plan? Why should I retain you? What are you going to do that the other family attorneys can't? I'm just going to say, I mean, the strategy, you talked about strategy, Mark. Our job is strategy. The strategy, I think, is to go to a place where you can get more fairness, right? People talk about, let's go to a different county, like go to a different country. Norway, they have better rules. I think realistically, your best bet is federal court. Your best bet is to make a constitutional claim in federal court. Constitutional claim for 50-50 parenting, if that's the issue. If it's parenting time, make a claim that Troxell v. Granville, the United States Supreme Court case, um, gives you a due process right to 50-50 parenting time. I don't think we've seen that wave. I don't think we've seen like people taking that shield and that sword and marching into the arena of federal court and saying, let's see how this shakes down, right? Try your circuit.
Hmm.
I don't know. Minnesota's the eighth circuit. Um, we haven't seen that battle go down. And I think that's the arena, and that's the argument over and over and over and over and over again.
Yeah, I think the biggest thing, and this is something actually I've kind of taken some time to study, and this is what we're chipping away at in federal court. So anybody who's saying, "Hey, I'm going to go file in federal court," there's something called, and I know you're familiar with Orion, the domestic relations exception, and it originally was this very narrowly tailored that basically said divorce and child support. Didn't even actually originally say anything to do with child custody, but divorce and child support, federal courts don't have jurisdiction of them. But it actually says nothing about child support, but it's been interpreted so broadly that federal judges for so long, if something like this comes into their realm, they just boot it out. And that's what we're carving away at. And you see some of these cases, and to the average person, they're like, what does that even mean? Well, maybe it creates more exposure for guardians ad litem, or it creates more exposure for the superior court judges in your state, or it opens up avenues to get into federal court. And like I said, there's a couple districts, or there's a couple of circuits now. Which, for those who don't know, the federal court system, you're going to have your essentially your trial court level, and then usually it's 3 to 5 states are in a circuit, and you go in front of a 3 judge panel, and when they make a decision, that holds precedent over all of the states in their circuit. And we've seen some of these circuits actually start chipping away and giving us those angles to get into federal court.
Mark, people ask me all the time, can we see the briefs? So I say constitutional argument, constitutional argument, constitutional argument, blah, blah, blah. People are like, wonderful. Can you send it to us? And is there a way that we could share? Is there a way that if I send you those documents as a PDF, we could post them somewhere or attach a link for folks so that they don't have to email me, they can just grab it?
Yeah, I can. So if you, I think we kind of left off and we never followed up. If you want to send over a redacted version or a version that's just generic, I can make sure that that gets up on the Fathers' Rights Movement's social media pages, and I can post it on my page as well. We can make it available on the Fathers' Rights Movement and then my page, the Fathers' Rights Attorney. So we can definitely get that information out to people.
Okay, so people should contact Mark or contact or follow the Fathers' Rights Movement.
Yeah, we'll get it posted on that page.
Okay.
I apologize. I have my email inbox has like 150 emails right now. So if you email me, it may be 10 to 14 days before you hear from me. But I'll get that as soon as I get that from Ryan. I'll get that over to the social media team with the Fathers' Rights Movement, and we'll get that put up there. So at minimum, you have that case law that's been done by, or that's kind of been researched and built out by Ryan.
And the one thing I would say, right, is so this was filed in Minnesota, but that doesn't matter for you, right? I mean, you can't just copy and paste the same thing, but you basically can. So the case law cited is United States Supreme Court. So regardless of what state, right, you would need to edit out the Minnesota and replace, your petitioner, your respondent with whatever is for your case. But the nuts and bolts, the meat and potatoes of this thing holds. And so for the same reason as Mark, I don't want to be non-responsive to folks who need this information and need it timely. So if we could just post it somewhere, I think that would help a lot of people. And
We'll
then,
get that out there. And I know we're gonna. I know. I don't think we're working on something with the Fathers' Rights Movement to kind of put all of the case law there is out there in the circuits and then at the federal Supreme Court level together, so it's all in one place. We understand that. I mean, to be honest with you, I mean, I'm not going to claim to be the world's greatest legal researcher. Um, but if you've never ventured down Westlaw and understand what the word shepherdize mean, it's next to impossible. So we're working on some resources to be able to get these in the hands of not just dads, but parents that are going through these issues.
so one last thing really quickly. So parental alienation, we mentioned this earlier, and this has been on the rise in the last couple of months for me, just litigating these issues. I think there's research, right? So parental alienation, first of all, like, you have to know that that's a thing. You have to know that world, that experience is labeled parental alienation. There's a huge body of research on this. And I think the point is, if you're in a situation where you're like, you know what, mom or dad's coaching the kids, there are often non-disparagement clauses in divorce decrees, right? Don't talk smack about mom.
Yep.
Don't talk smack about mom's boyfriend or girlfriend. Just keep everything positive with the kids. And you read it, you're kind of like, yeah, obviously, right? That we kind of just like blow it off, or it's so apparent and so obvious in terms of what good parenting looks like and there's animosity towards the other party. So it kind of gets lost in the mix. But that's a real problem from the child's perspective, right? From the best interest of the child, that's super, super, super damaging. So it's not just about mom hates dad or dad hates dad or the parents hate each other. The parents are talking smack. That's ridiculously toxic to the children in a way that is like suicidal ideation, depression, anxiety, all these things in kids, not just short term, but long term. And I don't know how much the judges have been trained on this, right? It's an open question. How, like, is this at the center of the judges?
Let me comment on that.
Yeah.
Let me comment on that. How much of the judge has been trained on it? Back in October, I was up in Orlando at the American Bar Association's Family Law Conference. There was a presentation by an attorney and a therapist, two of the most respected people in terms of research and litigating parental alienation. And a judge from Atlanta, Georgia, or the Atlanta area that oversees family cases, raised her hand and stood up and said, "It's impossible for me to say parental alienation has occurred because not one time in her 10 years on the bench had anybody presented her with what parental alienation was and what they were claiming." So running into court and saying parental alienation, that happens regularly and it's ineffective. you have to assume your judge knows nothing. That was kind of a shocking piece to me that she stood up and said, "I've never found parental alienation because no one's ever presented to me what their definition of parental alienation is."
Yeah, so what does that mean for people and their attorneys? Like so the judges are kind of like whatever. I mean, I'm not going to rule on it. It means and that's what I see as an attorney. The judges are kind of like we hear the words you're saying, but it doesn't like we don't have a checkbox for that on our sheet. Like we don't have template orders with that on our sheet. Mark, I think it goes to this problem that you just talked about. Like how do you educate the court without coming off as a patronizing pompous attorney, right? Or if you're self-represented, how do you do the same thing? How do you educate the court?
Yeah, I think for me, number one is you're going to lay the foundation with you're going to brief it, and you're going to be factual and you're going to be scientific, and evidentially, it's kind of that would be kind of questionable. Technically, to get anything in about that, you would probably have to put an expert on the stand and have an expert testify to it. But we know family court is the Wild West, and so I would go in and the book I always recommend is Litigating Parental Alienation by Ashish Joshi, who's a Michigan attorney who does litigate parental alienation. He wrote a book on it. And a lot of states actually have case law that lays out their standards and what parental alienation means. And all that information is in this book. And you can go in and educate your judge and present this factual information if it's available at an evidentiary hearing. You can put an expert on the stand and have them testify as to what it is clinically. And that's a little bit expensive, but like I told a client the other day, we can take factually what parental alienation is and how it's diagnosed, and your attorney can put that case on. Now most attorneys probably aren't going to be versed enough in it to be able to go into a trial and present parental alienation appropriately. But that's going to be one of the things in finding an attorney if you're in one of those high conflict situations that's going to be able to stand up there and walk through, hey, here's the cycle of parental alienation. Here's the non-exclusive 17 different behaviors that are associated with parental alienation. So you're going to want someone who can do that. You don't, I mean, literally a brief and then having an attorney who can walk through the steps of what it is clinically can be extremely impactful. Because, like I said, running into court and saying parental alienation, what can the judge actually even do? You really haven't presented them with anything.
I think that's right. I don't have anything to say other than to say I think that's right. Right? I think it doesn't sound like rocket. It doesn't. People may be like, yeah, obviously that's right. Obviously, you have to. The words parental alienation have to come out of your mouth if you're an attorney. Also, what it means has to come out of your mouth, right? What it is, the case law to support it. That's good lawyering. And so, Mark, you're right. I mean, if I was shopping for an attorney and I felt like parental alienation was at play and I heard you say what you just said, that would give me comfort, right? If whether we were going to litigate it or not, just to know that somebody had in their vision like the vocabulary to see like, yes, this is an issue, and to be able to tell the court, because let's give the court the benefit of the doubt for the second. Let's say that while they're not educated in this particular vice, like they're open to hearing and learning. So then all you got then your job is to educate. And I think as attorneys, we have to assume that the court, for our own sanity, we have to assume that the court has the best intentions. The court has the best interest of the child. The court wants to do what's right. The court wants to follow case precedent. And so we shouldn't make assumptions. We should just do our jobs and present the facts. And so that book that you mentioned is seminal, Litigating Parental Alienation. It is expensive, right? So it's not something that you could buy for 67 cents on Amazon used books, but I think it is worth it. It's the long version of what Mark just laid out. And, maybe what might be useful is that book's massive tome. Maybe it'd be useful to go through in like a 5-minute YouTube video or give a condensed Cliff Notes version. But, if you're going to invest in an attorney, you want them to be samurai.
Yeah, and I mean there are other resources. Like I'll pull this up here. Daniel makes this. There are so many people. Dr. Craig Childress is one of the preeminent experts in the space, and they have resources available that are more short form. Now that book, Litigating Parental Alienation, it's I would say 250 pages. It's a big textbook. It's very technical, but if you can boil it down simply, I mean, essentially parental alienation at its core, if we're going to be explaining it, is there was a bond between child and parent. Now there's rejection. And you have to fill in the blanks between those two.
Mm-hmm.
And Dr. Robert Simon out of, hopefully have him on the show here actually in the next month or so, out of San Diego is one. Dr. Craig Childress. In terms of litigating it, obviously Ashish Joshi is the guy. He travels all over the country. Another one, Amy Baker. I've read some of her stuff. So there's a lot of people, and you have to realize, like I had a client the other day who it's a very clear parental alienation issue. And I put that in our pre-hearing brief. And he freaked out. He's like, I read that you're not supposed to put it. That may have been the case 5 years ago.
Mm-hmm.
But there's been a lot of movement. And so it's a lot of times attorneys just simply haven't educated themselves. So if you're in one of those situations, you have to find someone who's either willing to educate themselves on it, because if there's parental alienation, if it's significant, you're probably going to be litigating it out. It's probably not going to be the type of case that's going to get settled. Or someone who understands and already knows what it is and knows how to litigate it. Because I think as much as prior to being an attorney, I viewed attorneys as every attorney is this brilliant constitutional scholar. That's just simply not the case. You can 100%. I would say that 80% of family law attorneys probably have never actually made. That's probably generous. Have never made a actual technical parental alienation argument in court.
Want to say one more thing. Dr. Childress's name was mentioned by a viewer. I would second that. I think he's incredibly knowledgeable. He's from California, but his research, his scholarship, his writing, first of all, there's a ton of it. Second of all, it's super accessible and free. So 2 thumbs up on that. Got to run, Mark, and everybody else.
Yeah, no, I know we were on a shot clock here. Thank you so much for coming on again. It's always a lot of information. For everybody watching, I know a couple people were asking for email addresses, different things to get that brief. Ryan's going to send a redacted version over to me. And in the next, give me a week to get it to the Father's Rights Movement social team. And we're going to get that posted. We may be able to get it on the website. We'll at least get it onto social media so everyone has access to it.
Awesome.
So once again, Ryan, thank you for coming on. To all of our viewers, I will be back again at our normal time next Thursday at 5 p.m. on December 23rd. So until then, thank you all for watching. And once again, Ryan, thank you so much for your time.
Thanks, Mark. Thanks, guys. Happy holidays.